Hello everyone, a very good morning. Welcome to the marathon class for Module D of our BRBL paper, December 2024 session. So due to some technical issues, we have rescheduled the class for 9 a.m. today. And today we are going to discuss all the questions. Through the questions, we are going to cover all the concepts, all the topics of Module D of our syllabus, the Module D in which there are some important acts. Also, we are going to study about the contracts, the conditions, pledge, what is the Limited Liability Partnership Act, how the companies can be formed, the Information Technology Act, and so on. So, this is an important module, all right. So, very quickly join the session, share it with your friends, and be ready to answer the questions. Okay. So, here's the first question from module D. The question says, according to the Indian Contract Act, what is the sum of a contract? What is the sum of a contract? We already know there's a difference between a contract and an agreement. We also say that every contract is an agreement, but not every agreement can be a contract. So why is that? What else is included in a contract? Contract that can be between one and two people or more than that. What all conditions are laid? Is it the sum of agreement and mutual understanding, agreement plus enforceability, consent plus obligation, offer plus acceptance? We already know consent is very important. Consent of both the parties is important for a contract to be legally valid. Another important thing is agreement, consent or agreement. Apart from that, apart from agreement, what else is required? We require the enforceability for a contract. So the contract means an agreement that is enforceable by law. Not only consent, a verbal or written consent, but we also need the contract to be enforceable, legally valid. Meaning that there are rights and obligations that are arising. So when two people they enter into a contract, they are bound by certain rights and obligations that they need to perform. So it is made by the free consent of all the parties. It is made by the parties who are competent. Competent means that they should be of the majority age. Plus, they should not be of unsound mind. It is made for a lawful consideration. It is made with a lawful object, and it is not declared as void by the Indian Contract Act. Therefore, contract is equal to agreement plus enforceability. So it should be with the consent of both the parties, and it should be enforceable by the law, enforceable in a court of law. So I hope you will remember this equation. Let's move on. The next question says, what roles do the promisor and the promisee play in forming a contract? Again, whenever we are talking about any relationship between two people involved in a contract, there has to be a person who is making a promise and the person to whom the promise is being made, the promisor and the promisee. All right, so let us see the statements. Promisor is the person making the proposal. Promisee is the person who witnesses the contract. Promisor is the person who accepts the proposal. And promisee is the person accepting the proposal. So you already know the meaning of a contract, the components of a contract, how a contract can be formed. Now you can define a promisor and a promisee. We have already seen their willingness. Let's say two people, they are coming together to form a contract. A will tell the terms and conditions. B will accordingly say whether they are willing to accept those terms and conditions or not. If both the parties are giving their consent, then we'll say this proposal. At first, when A is telling the terms and conditions, this proposal will only then turn into a promise. All right, only when B agrees to the conditions. So here A becomes the person who is making the proposal and B becomes the person who is accepting the proposal. Thus, we can say that A and D, that is promisor is the person making the proposal and promisee is the person who is accepting the proposal. And only when the consent of both the parties is received, we will say the proposal is a promise now. The proposal will turn into a promise or a contract will be signed. So the correct answer is A and D only. A and D only. I hope these definitions are clear. You should know the definitions of promisor, promisee, bailer, bailee, pawner, pawnee, mortgager, mortgagee. All of these are somewhat related. The person making the contract ends with the or term, and the person with whom the contract is being made, or the person who is agreeing, ends with the double e term. We'll see this in the further questions as well. Okay. What must be true for the sums paid in a compromise to be recoverable by the indemnity holder? First, you should know what is the meaning, who is the indemnity holder, whether it is the person making the proposal or the person to whom the proposal is being made. What is indemnity? All of these things you should know. So, contract of indemnity, we can say it is where one party they promise to save the other from the loss. We are saying that we are covering you, we are providing a cover for you, right? So when one party promises to save the other from the loss that is likely to be caused to them, then we can say it is a contract of indemnity. So here the promiser will be known as the indemnifier. The promiser who is making the proposal is known as the indemnifier, and the promisee will be the indemnity holder. All right. So now let us see, they must not be contrary to the indemnity. They must be authorized by a court. They must be less than the initial claim amount, or they must be paid after the suit is concluded. Yes, now answer this question. You know the meaning of the indemnity, indemnity holder, and the indemnifier. So the indemnity holder has certain rights against the indemnifier. That is, they can take a legal action against the person who has indemnified, or the promisor in this case. So the correct answer here will be option A. So all the details related to the rights of the indemnity holder are given here. The indemnity holder is the promisee or the person who is indemnified. The promisee we just discussed, the person who gives the consent, they have the following rights. So they can take a legal action if the promisor or the indemnifier they do not perform their obligations. So what all can they do? They can recover from the promisor or the indemnifier all the damages which may be compelled to pay in a suit in respect of any matter, then all the costs that may be compelled in bringing or defending in carrying on the suit, all the sums paid in compromise. This should be not in contrary to the indemnity. This should not be the first statement. It should be equal to already that has been stated in the indemnity or the cover that was agreed to in the beginning of the contract. And the right to sue for specific performance as well. If any specific performance it has caused an liability, so the contract will cover such liability. So these are the rights of the indemnity holder. They can cover all the costs, all the liability, all the damages that were caused to them. So this is the whole concept of indemnity. A cover is provided. So remember the concept, a cover is provided. Next question. Select the correct statement. These type of questions can also be asked in the true and false format. Which of the following statements are true or which of the following statements are false? State whether true or false. So a continuing guarantee cannot be revoked by the surety as to future transactions by notice to the creditor. Here you should very quickly remember the meaning of surety. Who is the surety? Any guarantee obtained by the meaning of misrepresentation made by the creditor is invalid. In respect of every contract of guarantee, there's an implied promise, again very quickly related to what is an implied promise and what is an express promise. Where there are co-sureties, a release by the creditor of one of them does not discharge the others. So here we are talking about the guarantees. And wherever we talk about guarantee, we are going to talk about a third person. The third person. So the person who is giving the guarantee is known as the surety. And the person in respect whose default the guarantee is given will be known as the principal debtor. So let's say there are three people involved, A, B and C. A is known as the principal debtor. C is the person with whom they will form a contact. If, however, A says that I'm not very sure whether C will repay or C will be timely in the repayment, so this person B will act as a surety. He will say that I guarantee you that C will make the payment. If C does not, then I will pay you. Right? And this does not end here. When the if C defaults and B makes the payment to A, B also has the right to recover it from C. So remember this relationship. Alright, so the guarantee here is talking about the surety that is given by a third person. Alright, so this is known as the contract of guarantee where three persons are involved. So A is the principal debtor, C is the creditor, and B will be the surety. Alright, so here the correct statements accordingly will be 2, 3 and 4. I will clear this. Yes, 2, 3 and 4. So continuing guarantee can be revoked by the surety as to future transactions by notice to the creditor. They have to give a notice to the creditor and then they can revoke the future transactions. Only the future, not the ones that were done before the notice. Future transactions, only those transactions that are done between the surety and the creditor after the receipt of revocation, not before. If any action was done before the notice was given, then those cannot be revoked. And any guarantee that is obtained by the means of misrepresentation is invalid. They cannot misrepresent. Any guarantee that has obtained by keeping silent to the material circumstance is also invalid. There is an implied promise by the principal debtor to indemnify the surety. So all of these things are there. So the correct answer is 2, 3 and 4. Where there are co-sureties, that is more than one sureties, a release by the creditor of one of them does not discharge the others also. So the surety release does not become free from the responsibilities to the other sureties in case there is co-surety. I hope you have understood the concept of contract of guarantee, how the contract of guarantee is formed between three people, right? So, yes, if not, let me know in the comment section. I will explain the relationship again. Okay. Select the correct statements about the roles in a bailment. Okay, now we are talking about bailment. What is bailment? Who are the people involved in bailment? This also is covered under the Indian Contracts Act of 1872. So, bailment basically, if we see the exact meaning, it is the handling over. Handling over. Giving. If I give you this pen, this can be a handling over or bailment, right? In simple terms. Or change in the possession of a movable property from one person to another person. That is bailment. So under this, the person delivering the goods is called the bailee. The person to whom the goods are being delivered is called the bailee. The person delivering the goods is called the bailer. The person to whom the goods are being delivered is the bailer. When we were discussing about the promisor and the promisee, I told you about the words ending with or and double e. So or and double e, bailer and bailee, the person delivering the goods, the person to whom the goods are being delivered, the first person and the second person. This way we can connect each and every relationship in all of these contracts. So the correct answer will be B, that is the person to whom the goods are being delivered is the bailee, and the person who is delivering the goods is known as the bailer. The person performing their duty is the bailer, and the person to whom the goods are being delivered is the bailee. So, bailment is derived from the French word baillir, which means to deliver, and in the legal sense, it is mean any kind of handing over or change in the possession of movable property. That is the definition that we all remember. Handing over of the property of the movable goods or the change in possession, right? We have mucked up this definition and it is the only definition. So as per section 148 of the Indian Contracts Act of 1872, it defines the bailman, bailer and bailee. Bailment is the delivery of goods by one person to another for some purpose upon a contract which is accomplished, the return or otherwise disposed. There can be two conditions. Either the bailee can say after the contract, let's say of 2 years is done, you need to return the goods to me, or they can say that you can dispose it off as per the contract, right? The person delivering the goods is called the bailer, and the person to whom they are being delivered is called the bailee. This is the definition of bailment, bailer, and bailee. And this is the relationship between the two. I hope it is clear. Okay. Next question. Select the correct statements about the rights of a bailee. So now definitely the bailee will have some rights. A bailee can retain the goods that are bailed to them until he receives due remuneration for the services rendered involving labor or skill. So if the bailee, if for example, let's say a person A gives a person B some raw material, let's say cotton, okay, and this person B now uses this cotton to make some textile or clothes. So in making of these clothes, what they do, they need to incur some labor and other costs of machinery. So can they recover these labor and costs of machinery from the baler, the person who has provided the cotton? We'll see. A baler must return the goods immediately after the service is completed, or after the service is completed, the clothes have been made, they cannot keep it for any longer, they have to return it. A bailee has no right to retain the goods for any reason, or a bailee can sell the goods if the payment is delayed. Which of the following rights does the bailee have? So the correct answer, I hope you would have guessed it, the correct answer will be A. That yes, these costs will be recovered. So if the bailee has rendered any service involving the exercise of labor or skill in respect of the goods that are bailed to him, he has the right to retain such goods until he receives due remuneration of the services that he has rendered. So the bankers, factors, attorneys of high court, policy brokers, if there's absence of a contract to the contrary, then they can retain any goods that are bailed to them as a security for a general balance of account. So they can retain the goods. They are not required to immediately return the goods until and unless the remuneration or the payment for all the skills labor have been made. Right? So the correct answer is this. Now there can be a implied express, or there can be a expressed contract here. So these entities, even if there is an implied contract for the remuneration, they can enjoy it, but others, they need to have an express contract to that effect. Okay, so this is the correct answer. Next, select the correct statements about the essential ingredients of a valid pledge. Now here you will tell me what is the difference between a pledge and a lien. How do these two differ? So let us see what are the statements given about a valid pledge. The property pledged should be delivered to the pawnee either actually or constructively. The pawnee retains both special and general property in the pledge. The general property remains with the pawner and the wholly reverts to him on discharge of the debt. The pawner has no right to reclaim the property after the debt is paid. Again, two terms are given to us. We have the pawner and the pawnee. OR and double E. I won't repeat it again. I hope you know the meaning. How you can differentiate between these two terms, ending with OR and ending with double E. So, when we talk about a pledge, okay, so there's a difference between a pledge and a lien. In lien, there is no power. In lien, there is no power to sell the goods or dispose the goods, whereas this power is there in the pledge. In case of default, pledge has a power, the pledge contract has a power to sell. In case of lien, again there is no transfer of interest. The person who is exercising the lien only has the right to retain the subject matter until it is paid, and then it becomes loss, there is no right of sale. Whereas the pledge, the sale can be made in the case of default, or we can say the pledge is assignable. The pledge is assignable. This is what we have studied, right? The difference between pledge and a lien, where a sale can be made in case of default and where it cannot be made, right? So this is the meaning. Using this meaning, we can answer this question now. So I will erase this. The correct answer will be option B, that is 1 and 3 only. 1 and 3 only. So what all constitutes in a valid pledge? A contract in relation to an identified chattel to be delivered to the pledge as security, then the actual delivery of the possession in pursuance of the contract. Valid pledge, what all will be included in the valid pledge? The property should be actually or constructively delivered to the pawnee. Again, the person who is delivering, the first person is the pawner, and the second person to whom the delivery is being made is the pawnee under a pledge. So the pawnee has only a special property in the pledge, while the general property remains with the pawner and wholly reverts to him on discharge of the bill. So the general property remains with the pawner, and the special property, it is given to the pawnee. All right, only special property is with the pledge. Pawnee has only the special property, and the property should be delivered to the pawnee either constructively or actually. So here the difference between lien and pledge is given. There's no transfer of interest in a lien. There's no authority or power to sell off in case of default, but this is there in the case of a pledge. So the correct answer will be A and C. So if the pawner makes a default in the payment of the debt in respect of the goods that were pledged, then the pawnee may bring a suit against the pawner, and they can retain the goods that are pledged in the security after giving notice of the sale to the pawner as well. This is the main agenda of the pledge. So the pawnee has more rights. Alright, so the correct answer is 1 and 3. Next question. Select the correct statements about the legal consequences of contracts that are entered through an agent. Now, agent can be a middle person in simple terms. If we are using a third party or an agency to sign a contract between two people, then what are the legal consequences? So the contracts entered into through an agent have the same legal consequences as if entered into by the principal. The contracts that are entered through an agent are invalid unless they are ratified by the principal. The obligations arising from the act done by an agent are enforced in the same manner as done by the principal, or the principal cannot be held liable for the contracts that are made by the agent. So the contract of agency, wherein if there is a need that we need to employ a third person to act, like if in the case of the principal they want a third person to perform the duties, act on behalf of them or represent them in dealing with the third person, that is the contract of agency. So what is the definition of agent and what is the definition of principal? Agent is the person being employed to do an act on behalf of another person or to represent another person, and the person for whom the act is being done or the person being represented is the principal. All right, so agent is the person being employed, and the person who is employing this agent will be the principal, the employer or the person who is being represented by the agent. This is the definition. Now there are some essential characteristics, or we can say there are some legal principles of the agency. So which of the following accordingly are correct? Right. So let us move on to the correct answer. The correct answer is option A, that is 1, A and C. The contracts entered through the agent have the same legal consequences as if entered to by the principal. That is, the principal has to be of competent mind. The agent has to be of a competent mind. They should be of the majority age. They should not be of the minority age. And the obligations arising from the acts done by the agent are enforced in the same manner. It does not matter whether the principal is making the agreement or the agent is making the agreement. So there are two important rules of agencies. These important rules are that the first rule is that whatever a person can do personally can also be achieved through an agent, right? If I am performing the duty, the same things will apply if I'm asking another person to perform that duty for me. Same thing can be done. That is why we can employ the agent. Second, he who does an act through another does it himself as well. This means that an act of an agent is subject to certain conditions or acts of the principal. Contracts entered through an agent and obligations arising from the acts whereby an agent may be enforced in the same manner. So they will have the same legal consequences. The principal cannot say that I have not performed the act, it is performed by the agent, so the legal implications are not implied. No. Same legal consequences will be there if the act was entered into by the principal. Alright. So the rights given to the person to represent in dealing with the third person, these are the same as if it were performed by the principal themselves. So these are the two rules. Also, the agent should be competent to the contact. So let's say if A person buys goods from B person, knowing that this person is the agent for the sale. That is, if A person is buying from B and B is the agent, they are not the principal but they are the agent, and A knows this, but they do not know who the principal is, then this agent's principal is entitled to claim from A person the price of the goods. All right, they cannot, the person A cannot say that no, I took the goods from agent so I will not pay to the principal. No, it is the same thing whether the agent is making the sale on behalf of the principal or the principal themselves are coming into the contract. So they will remain the same. Okay. Next, under section 215 of the Indian Contract Act, what can the principal claim if the agent deals in the business on their own account without the knowledge of the principal? Now, if this agent, if the agent without telling the principal, they are using their own contract or they're by themselves taking some decisions, so what can the principal do? Can the principal compensate for the damages? They can seek compensation for the damages, or they can seek any benefit that results, the agent's personal assets, or can they terminate the contract? What if the agent on their own is taking some decisions? So So, yes, we have already discussed that all the rights of the agents are there, that they need to perform their duties to the principal. But also, there are rights of the principal, such as the right to recover any damages in case the agent neglects to follow the directions, or to recover any secret profits of the agent that were not disclosed to the principal. Or they can also resist the agent's claim for indemnity that are against the liability that are incurred under certain circumstances. So the principal has their own duties as well as their rights. Okay, so the correct answer here will be option B, that is any benefit that has resulted or any profit that has resulted. So there are the duties of an agent to carry out the work undertaken as an agent as per the directions given by the principal, to carry out the work rationally and with care to not cause damage, then to render the proper accounts to the principal on demand and to not cause any loss due to misappropriation or fraud, to communicate with the principal if they face any difficulty in the discharge of their function and seek instructions, and to pay the principal or sums received for him after deducting all the money that were due to themselves. All right. In terms of section 215, if an agent without the knowledge of the principal deals in business of the agency on his own account instead of on the account of the principal, then the principal is entitled to claim from the agent any benefit or profit that may have resulted to him from the transaction. So this is the correct answer, that the principal can claim any benefit that has resulted. This is given under section 215 of the Act. So correct answer is option B. Next, what characterizes an absolute contract for the sale of goods? Absolute contract for the sale of goods. So when we are talking about the sale of goods, we are talking about the Sale of Goods Act of 1930. And the terms that are given under this contract, like buyer, the immediate meaning of buyer, the person who agrees to buy goods; seller, who agrees to sell the goods; price will be the money consideration for the sale of goods; delivery will be the transfer of possession; document of title to deeds, this will include what all documents are there, like the bill of lading, the dock warrant, or the warehouse keeper's certificates, railway receipt, anything, all the documents. All right. Then there are specific goods, there's a mercantile agent, various definitions are given. So when we are talking about the contracts, or we are talking about the sale, so there is the absolute contract for the sale of goods. What does it mean? Conditions must be fulfilled by the seller. No conditions need to be fulfilled by the seller or buyer. The conditions must be fulfilled by the buyer. The conditions need to be negotiated after the sale. Which of the following is correct? Whether A, B, C or D? The correct answer here will be option B, that is, no conditions need to be fulfilled by the seller or buyer. So there are two types of contract that can exist. Either the contract of sale may be absolute or it can be conditional. Absolute contract means that there are no conditions to be fulfilled by the seller or the buyer for the sale of purchase of goods. So there is no condition in the case of absolute. No. Then in the case of a conditional sale, the parties to the contract, they agree that the sale of goods shall be regarded as final only on the fulfillment of certain conditions. So that is why it is termed as a conditional, because conditional or conditions are applied. Okay, so only if both the buyer and the seller, they are fulfilling the conditions, then we can say that it will be done or it will be a complete contract. So unless a different intention appears from the terms of the contracts, the stipulations as to the time of the payment that were made, they are not deemed to be the essence of the contract. So all of this information is there. So difference between absolute and conditional contract, sale of goods. Absolute means that no conditions, and conditional means that yes, conditions have to be fulfilled. So the correct answer here will be option B. Okay, next question. What are the expressed conditions and warranties in a contract of sale of the goods? There are certain expressed conditions and warranties when we talk about the sale of goods. So those implied by law to every contract of sale of goods, those that are stated orally between the parties, those that are expressed stated in a contract, or those which can be implied only by the buyer. So there are some conditions and warranties in the contract of a sale, right? There are certain stipulations, terms and conditions related to the nature, the quality, like the condition can be the quality of the good that has to be same as stated by the seller. Then it should be the sample and the description should be same. Then the fitness, quantity, they should not differ as were stated in the contract when it was made of the buying and selling. So condition, we can say it is a stipulation. Warranty can be, we can say that it is a guarantee sort of. it is a stipulation collateral, that is a warranty. So if the stipulation that is agreed to between the parties, it is essential to the main purpose of the contract, then a party to the agreement would say that yes, we have termed the condition, we have stated the condition, and they have the right to treat the contract as repudiated or cancelled if the condition is not followed or if the condition is not fulfilled. Warranty, we can say it is a stipulation collateral to the main purpose of the contract. So the breach of such a warranty gives right to the claim of damages only. It cannot reject. Okay. In the case of breach of a condition, what can the person do? They can cancel the contract. But in the case of breach of a warranty, they can only claim the damages. They cannot cancel the contract. Right? So the correct answer here will be option C. That is, those expressly stated in the contract. The conditions and warranty should be expressly stated. They cannot be somewhat orally stated or that were not agreed to at the time of the sale, contract sale. So in a contract of sale of goods, conditions and warranties may be either expressed or implied. Expressed conditions and warranties which are expressed stated in the contract, they are exclusively stated and agreed to. Implied will be there which the law interprets to imply to every contract of the sale. We are not agreeing to. We might say that this is implied, this is given. We need not say it otherwise, this is given only. But express conditions will be those that are stated separately. Like if I say that the goods should be of a branded quality, then I'm expressing my condition. On the other hand, if I do not say it, I just believe that yes, the goods would be of certain good quality, then it is what? It is implied. So such implied conditions and warranties can be excluded by the parties to the contract. So if there is implied condition, then the seller can, they have the right to sell the goods, or they have the right to sell the goods at the time when the ownership is passed to the buyer. Okay, in the case of expressed only, the buyer can say that we will cancel if you do not meet the conditions. Okay, according to the doctrine of caveat emptor, who is responsible for examining the goods before the purchase? So here we are talking about the implied conditions and warranties. So caveat emptor is basically meaning beware. Beware or take certain precautions. So who is responsible to take the precaution? Whether it is the buyer, the manufacturer, the seller or the government. So caveat means a warning or a caution. And this caution should be taken by the person who is buying the goods. Basically, they should keep their eyes open, they should check the goods before they're receiving them. So the correct answer is the buyer. So there's an implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party. This means that the buyer can assume that the goods that are being sold to them would be of absolute property, right? So before they are receiving the goods, they can check the quality of the goods. So caveat means a warning. According to this doctrine, the person who buys the goods must keep his eyes open. This means the buyer must examine the goods thoroughly. And if the goods do not serve the purpose, or he depends upon his own judgment and makes a bad choice, then they cannot blame the seller for selling him these goods. Why? Because it is implied. It was not stated expressly. It was not expressed in the contract. So they cannot claim or they cannot blame the seller. So there is no employed warranty or condition as to the quality or fitness of the goods for any particular purpose. Only if they are specifically expressed. If they are specifically expressed in the contract, then the buyer can claim. Otherwise, in the implied claim, they cannot. Right? So buyer, the doctrine of caveat emptor falls on the buyer. Next question. What rights does an right does an unpaid seller have if he has made the part delivery of the goods? So if the seller, they are making the delivery half of the goods that were agreed in the contract, they have delivered the goods but they have not yet received the payment for that delivery. So what right do they have? The right to retain the balance goods under lien, the right to demand full payment immediately, the right to cancel the credit agreement, the right to retain only a portion of the remaining goods. What right does the unpaid seller have? Unpaid seller. So the seller of the goods will be said to be an unpaid seller if the whole of the price has not been paid or tendered, or when the payment for the goods it is received in the form of check or any other negotiable instrument and the same is dishonored, like if the check bounces. So the seller who is making the delivery of the goods and they're not receiving the payment, unpaid seller, that will be the unpaid seller. So they have certain rights that they can perform if they have delivered the property and they have not received the payment. And this right is that they have the right to retain the balance goods under lien. So the unpaid seller, we have already seen if the goods have been sold without any stipulation as to credit, if the goods have been sold on credit but the term of credit has expired, and if the buyer becomes insolvent, then they can retain the possession of the goods until the payment of the price is made. All right. Where the unpaid seller has made part delivery of the goods, they may exercise the right of lien on the balance goods and they can retain the remaining part until and unless the delivery is being made. Right? So he is in the possession of the goods. So the correct answer is option A. They have the right to retain the balance. This is the unpaid seller. Okay, they can terminate the lien. The termination of the lien can be there if he delivers the goods to a carrier or the bailey for the permission of transmission, and without reserving the bill of the right of disposal of the goods, or the buyer or the agent they lawfully obtain the possession of the good, or by the waiver of the lien. They can also be the right of stoppage in transit if the buyer becomes insolvent, right? So all of these conditions are there. Next, what does a partnership at will? When does a partnership at will get dissolved if no date of dissolution is mentioned in the notice? So now we are talking about the partnership, partner under the Partnership Act of 1932. All right. So the provisions relating to the partnership contracts. Partnership is the relation between persons who agree to come together to share the profits of a business that are carried on all, or they or any person who is acting on behalf of them, right? So individually all of these persons will be called partners and collectively they will be called a partnership firm. So which of the following is correct if no date of dissolution is mentioned in the notice? Then from the date the firm was established, from the date mentioned in the notice, from the date of commencement of the notice, after 1 year from the date of the notice. Answer this question. Yes, so if in case in the notice the time of dissolution is not mentioned, then from the date of commencement of the notice, we can say that it will get dissolved. The partnership act will get dissolved. So when there is no provision made in the contract between the parties for the duration of their partnership, like for how long the partnership will continue, then for the determination of the partnership, it is known as the partnership at will. That is, the termination or end is not made sure in the contract. So it is known as a partnership at will. So there are three types of partnerships. We have the partnership at will, we have the partnership for a fixed period, and we have a particular partnership. So partnership at will is stating that we are not going to mention any date of dissolution. It will be at will. Whenever we decide to dissolve, whenever we decide to stop the partnership, we can do so. So a partnership at will can be dissolved by any partner by giving notice in writing to all the other partners, and it will get dissolved from the date mentioned. And if no date is mentioned, then from the date of the commencement of the notice, the firm will get dissolved. So at will, at their own discretion, they will decide when to dissolve. They're not going to write it in the contract at the time when the partnership was being made that when it will get dissolved. At discretion, when the partner deems fit that yes, now the partnership firm can be dissolved. Then partnership for a fixed period, when the partnership agreement is made for a fixed period of time. In such case, when the fixed period of the partnership over, then it comes to an end. However, if the partners they agree, they can continue it further. In that case, the mutual rights and the duties will remain absolutely unaffected as they were before the period came to an end. And then third is a particular partnership for completing a particular job. And when the particular job is completed, then what will happen? The firm will automatically be dissolved. So hence a person can become a partner with another partner in particular adventures or undertakings. Like if they agree to establish a particular goal, and when the goal is established, then the firm will get dissolved. So these are the three options: at will, for a fixed period, and third option is what? For a particular goal. Next, what if, what are the implications if the number of partners in a partnership is reduced to one? What happens if, let's say, more than one partners were there, but all of them they leave the partnership and it is reduced to one? Then the partnership ceases to be a partnership. The partnership remains legally valid. The partnership transforms into a sole proprietorship, and the partnership becomes an illegal association. So what will happen if other partners they leave the firm or they leave the partnership agreement? So there are certain rights and liabilities, the mutual rights and liabilities under the partnership, which are agreed in a contract between the partners. Like the partner is not entitled to receive the remuneration for taking part in the conduct of the business, or they are entitled to share equally the profits. Then the capital that is subscribed to him will be entitled, right? So all of these things are there. So, if the partner is reduced to one, then the partnership ceases to be a partnership because now it has only one person. There are no persons who are going to be the partners, and the partnership transforms into a sole proprietorship. The person is the sole authority. So the agreement between two or more persons, the maximum number of persons, it is determined by the Companies Act. It has prescribed that the number of persons in case of the partnership should not be more than 100, and the powers given to the central government, they can notify the maximum number within the limit of 100, right? Okay. So using this power, the central government has allowed the maximum number of persons to be 100. Thus, if the number of persons exceed, then it will become an illegal association. So the partnership will become an illegal association if the partners are more than 100. Here the person does not include another partnership firm. One partnership firm cannot come into another partnership with a separate partnership firm. Only different persons they come together and they form the partnership. Hence, two partnership firms cannot enter into a partnership. Though all the partners they may join to become a partnership. So people they come together to form a partnership. No firms can come together to form the partnership. Alright. So the correct answer is option 4, that is A and C. Next question. How are the mutual rights and duties of the partners affected when additional undertakings are carried out by a firm? When we were discussing about the three types of partnerships, so we had the fixed partnership model, wherein after a term the partnership firm automatically dissolves. If let's say they do not decide to dissolve, they say that we want to continue, we want to take additional undertakings, or if the goal is accomplished, we say no, we will take additional adventure or venture. So what will happen? They change, the mutual rights and duties change based on the new undertaking. They remain the same as those in respect of the original undertakings. They are left undefined, or they are determined by the external advisors. So what will happen if they extend their functions? So after the expiry of the term of the firm, if the firm they continue to carry on business, then the mutual rights and the duties of the partners will remain the same as they were before the expiry. And when additional undertakings are carried out where the firm constituted to carry out for one or more adventures, then what will happen? The mutual rights and the duties of the partners, they will again be the same in respect of the original adventures or undertakings. So they will not change. They remain the same as those in respect of the original undertakings. So after a change in the partners of the firm, the mutual rights they remain the same as they were immediately before the change. Similarly, after the expiry of the term, if a firm constituted, what will happen? The additional undertakings, they will have the same mutual rights and obligations and duties as they were in respect of the original adventures. So the partners, they are free to have an understanding that if they want to continue, then the rights and the powers will remain the same. So the correct answer is option B. In all the conditions, they will remain the same. Next, what must a partner have to open a banking account on behalf of the firm? So, if a partner in the firm wants to open a banking account, and this will be on behalf of the whole firm, not individual, but for the firm collectively. So, what must they have? Should they have the implied authority? Should they have the verbal consent from one partner? They should have the express authority from other partners, or majority vote in favor from the partners. What is required, which condition is required if they want to open a firm, a bank account for the firm? Okay, so yes, the correct answer will be option C, that they should have the express authority from other partners. They cannot, on their own sole decision, individually open a banking account on behalf of the firm. They should have the expressed authority that all the other partners they are giving their consent. Only then can this person open a bank account. So, where there is no usage or custom of trades to the contrary, the implied authority of the partner does not allow. Implied authority which is not stated otherwise, it is only assumed, it will not allow submitting a dispute pertaining to the business of the firm or arbitration, open a banking account on behalf of the firm, compromise or relinquish any claim that is filed on behalf of the firm, withdraw a suit or proceedings that are filed on behalf of the firm, admit a liability in a suit or proceeding, acquire or dispose of the transfer of immovable property, enter into a partnership on behalf of the firm. So there are two types of powers we can say that the person has. They can have the implied power and they can have the expressed power, right? So the rights and duties. There are mutual rights and then there are duties or rights that the person individually has. The partners of the firms they can decide their mutual rights and duties with the consent of all the partners, and this may be either implied, that is they're understood by the dealings between them, or they may be expressed that are specifically agreed and are made clear. However, they should not be against the provisions of the Partnership Act, right? So every partner has a right to take part in the conduct of the business. They are bound to attend to the duties and conduct of the business. Any difference, if existing, they have to be decided by majority of the partner. No one person can individually take the decision. Also, every partner has a right to access and inspect the copy of other books. So these are the implied duties and rights. There are mutual rights and liabilities, and this includes that only with the express authority can the person open a banking account. They cannot do so in their own decision. All right, next question. Which scenarios exempt the legal heirs or the estate of a deceased partner from the liability? Read the statements very carefully. So what happens if one of the partner in the firm dies? So will the legal heirs have to bear the liability or not? When the firm carries on business in the old name after the partner's death, when the legal heirs are actively involved in the business, when the firm continues to use the deceased partner's name without the heirs' consent, and when the legal heirs have no involvement in the firm's operations. So when can the legal heirs or the of the state of a deceased partner, they can be exempt from the liability? Yes, answer this question. Okay, the correct answer is option 4, that is A and D, that the legal hire will be exempt from liability if the firm carries on business in the old name after the partner's death, and when the legal hire have no involvement. They will not be exempt if they are actively involved, or if the firm continues to use the deceased partner's name without the hire's consent. Okay, so anyone by words spoken or written by the conduct represents himself or knowingly permits to be represented by a firm, they are liable to be a partner in the firm. So this is known as the doctrine of holding out. There are various doctrines that govern the liability of the partners in terms of the firm. This means that when a person who is not at all a partner in the firm or knowingly they permit himself to be representative, he induces others to give credit to the firm when he is known as a partner holding out. So this will be a stranger, and this stranger is liable individually and personally for the debts of the firms. However, if we are talking about the legal hires, in case of holding out, this will be there. But if we are talking about the legal hires of the or the estate of the deceased person, then they are not liable to the firm. They will not be liable to the firm in these two conditions. Okay, so go through this explanation and you will understand what is the meaning or how the liability will fall on the person. So when we talk about the liability, so liability of the firm for the wrongful acts of the partner, or liability of the partner for the acts of the firm, or if there is a misapplication by partners, then what is the liability of the firm? All of these things are there. Okay, next question. Who is personally liable for the liabilities of the firm? Which person is personally liable? Only the minor partner, the minor's legal guardian, all the partners except the minor, or all the partners including the minor? So here we are talking about when a minor is admitted to the benefit of a partnership. So we know that minor is not competent to enter into a contract, so they are not eligible to enter into the contract of a partnership as well. right? Thus, in no circumstances can the minor be made a party for the liability of the firm. So the minor cannot be a partner. All right. But in, however, all the partners, they are coming together, they're acting together, and after the time of attaining majority, what all conditions will be there for the minor? Like when any person has been admitted as a minor to the benefits of the partnership in a firm, then the burden of proving that the person had no knowledge of such admission until a particular date after the expiry of 6 months of their attaining majority will lie on the persons that are asserting the fact. It will lie on the persons that are attaining the fact. So again, if we are talking about the liability, so it will be all the partners except the minor, because the minor is not competent to be entered into a partnership, right? So thus a minor has a right to share the property and profits of the firm as may be agreed upon from the partners, and they have the access to the accounts of the firms. But all the partners of the firms are personally liable for the liabilities of the firm, and the minor is not liable. The minor may or may not take legal action against the partners for the payment of his share on the property or profits of the firm except when ending his connection with the firm. So they are not legally competent to enter. So whenever a minor becomes a partner, then their rights and the liabilities, they continue up to the date on which he becomes a partner. Then his share of the property and the profits shall be the share to which he was entitled as a minor. It will continue up to the date on which he is given a majority or he attains the majority. Okay. Next, under what circumstances is a retiring partner still liable for the acts that are done before retirement? So, a partner may retire, a person who is a partner in the firm, they may decide to retire, but they can do so with the consent of all the parties and in accordance with the express of the agreement by the partners, or wherever the partnership is at will by giving notice in writing to all the other partners, but they have certain responsibilities. So, when can the retiring partner be still liable? Until the public notice of the retirement is given. If there is no agreement with the third party regarding the discharge of liability, if the retiring partner announces retirement verbally, or after the firm is dissolved. So, under what circumstances is the retiring partner still liable? So, the retiring partner and all the other partners, they shall be liable to the third parties for any act that is done by them before retirement until the public notice is given of the retirement. So, before their retirement, before the public notice is given, they will be liable, right? And the retiring partner is discharged for his liability only after this agreement is made between the third party. So the correct answer is option 2, that is A and B. Until the public notice is made and if there is no agreement with the third party. If the third party does not know of the retirement, then also the retiring partner will be liable. Alright, they do not retire, they do not announce it verbally but on a public notice, and after the firm is dissolved, then no reason is there to continue the liability. So the correct answer is A and B. So how can a partner retire? With the consent of all the other partners, accordance with the express agreement by the partners, where the partnership at will by giving notice in writing to all the other partners they have the intention to retire. They will be liable as partners to the third parties until the public notice is made, and the public notice may be given by the retiring partner or the remaining partners of the constituted firm. So the retiring partner is discharged of his liability to a third party for the acts of the firm before his retirement if again there's an agreement between the third party, the retiring partner, and the remaining partner. So this agreement should be between all the three parties. The person who wishes to retire, the third party, and the remaining partners of the firm. If they agree, then the person will be discharged of his duties that were there before the retirement. I hope this is clear. If not, you can let me know. These are the basic terms and conditions as to the functioning of partnership. All right. Next, what is one of the circumstances that leads to the dissolution of a firm under the section 42? So when can a firm be dissolved? Yes, a partnership firm can be dissolved, but the dissolution of a firm and the dissolution of a partnership, these are two distinct actions and we should know the difference between them. Dissolution of a firm would be the termination of the firm and end of the business relationship among the partners, right? When we are talking about the dissolution of the firm, so the complete firm is dissolving along with the partnership. But when there is only a dissolution of the partnership, there's only a change in business relationship and the firm it continues to run. So when a partnership is dissolved, the firm will still continue. It will not be dissolved along with the partnership. We can say that there's only a change of business. So there's a difference between these two and you should remember this difference. Now let us read the statements. So what is one of the circumstances that leads to dissolution of the firm? We are talking about dissolution of the firm. The partnership's financial loss, the withdrawal of the partner's capital, the death of a partner's leave of absence. So a firm will be dissolved compulsorily or in case of certain agreements the firm can be dissolved. Compulsorily dissolution of a firm will take place if all the partners are adjudicated insolvent, if all the partners are stated as insolvent, or by the happening of any event that makes the business unlawful. All right, unlawful. But if the partnership firm is working on more than one particular business, then the illegality of one or more does not cause the dissolution of the firm. Only if the whole firm is declared as illegal or insolvent will it be dissolved. So here the correct answer accordingly will be the death of a partner. If let's say a firm is dissolved under the statute section 42 under the certain circumstances. If the partnership firm is constituted to a fixed firm, then by the expiry of the term, the firm can be dissolved. If the partnership is constituted to carry out one or more adventures or the undertaken, then by the completion of all of these, or by the death of a partner, or by the adjudication of the partner as an insolvent. In this case, the firm will be dissolved. So the correct answer will be by the death of the partner. If the partner leaves on absence or the partner withdraws its capital or there's financial loss, then the firm will not be dissolved. All right, so these are the various cases. Then dissolution on the happening of certain contingencies. Apart from that, dissolution can also be taken by the court. If there's a filing of suit by the partner, then the court may dissolve. If the partner has become of unsound mind or the partner has become permanently incapable of performing their duties, or they are found guilty of conduct or prejudice, right? So this will be the case where the court is going to dissolve the partnership. Otherwise, in these cases, after the completion of the term, completion of the project or death of the partner, the firm can be dissolved. This is given under section 42. Next question. Under what conditions is the estate of a partner not liable for the firm's acts after the partner ceases to be a partner? what happens or what are the liabilities of the acts of the partners after the dissolution, or once they are not more anymore the partner in the firm. So if the partner has died, if the partner continues to manage the firm, if the partner is adjudicated insolvent, if the partner retires without notifying the third party. So, under which condition is the estate of a partner not liable for the firm's acts after the partner ceases to be a partner? So, the partner has moved out of the partnership, and in which condition will they not be liable? Will the estate be not viable? Let us see the correct answer. The correct answer is option 4, that is A and C. If the partner has died, or if the partner, if A and C, or if the partner is adjudicated insolvent, then they will not be liable for the firm's acts after the partner ceases to be the partner. So any or all partners of the firm, they must give a public notice to the effect that the firm is being dissolved. This is because even after the dissolution of the firm, the partners continue to be liable for any act that is done by them until the public notice is given. So until the public notice is given, the people will be liable, right? So the partners, they continue to be liable to the third party for the act that were done by them, which would have been the act of the firm, if before the dissolution and until the public notice is given, provided that the estate of the partner who dies or who is adjudicated and insolvent, or a partner who is not been known to the person dealing with the firm to be a partner, they retire, then they are not liable under this section. All right. Or second, notices under subsection 1 may be given by any partner. So in these cases, the partner is not liable for the firm's acts after the partner ceases to be a partner. If they have died or if they are adjudicated as insolvent, they will not be liable. Next question. What is the consequence of not registering a partnership under section 69? So, a company is compulsorily required to be incorporated and registered with the Registrar of Companies under the Companies Act of 1956 or 2013. However, a partnership firm is not required to be compulsorily registered with the Registrar of the Partnership Firm. So, company has to be registered, but the partnership firm does not require compulsorily to be registered with the partnership firm. So the question is asking us, what is the consequences of not registering the partnership firm? The firm cannot exist legally. The firm cannot enforce any right to sue after dissolution. The firm faces certain disabilities, or the firms are personally liable. I just said that they are not compulsorily required to get registered. So they can exist legally or they are liable, but they do face certain restrictions. These are given under section 69. So the correct answer is option C, that is the firm faces certain disabilities. All right. They can exist legally. It is not mandatory for them to register, but they face certain disabilities, like no suit to enforce a right can be made, or herein the enforcement of any right to sue for the dissolution of the firm, for the accounts of a dissolved firm can be made, right? So there are certain disabilities they face, but still they can choose to not get them registered. So the partners may or may not enter into a partnership deed and may decide to have an oral partnership if they have a strong understanding among themselves. Further, even if a partnership is entered into, the partners, they may opt for not registering with the partnership firm. However, the Partnership Act casts certain disabilities on the partnership firm if they are not registered with the registrar of the partnership firms. So this is given under section 69. A majority of the partnership firms, they decide to register the firm to avoid the future hassles and complexities. However, the enforcement of any right to sue for the matters relating to the dissolution, they are not affected, and they can be brought before the court of law, right? So other things are not there. Whether you are registered or you are not registered, these will remain the same, but you will face certain disabilities. Next question. What change did the amendment to Section 46 of the Companies Act 2013 introduce regarding the common seal? So the amendment was made to the Section 46 of the Companies Act. According to that, what was done to the common seal? Whether it made the use of common seal optional, it mandated the use of common seal for all the documents, it prohibited the use of common seal altogether, or it allowed the common seal to be used only by the company secretary. Which of the following is correct regarding the common seal? The amendment that was made. So yes, the correct answer is that it made the use of common seal optional. It did not prohibit or it did not made it compulsory, but it made it optional. So as a company is an artificial legal person, it is not capable of signing the documents for itself. It acts through the natural persons who are the directors appointed by the shareholders of the company, right? But these persons can be responsible legally. So, hence the law provides for a common seal with the name of the company engraved on it as it substitutes for its signature. So, the person, they need not use their individual signatures, they can simply use the common seal for the whole firm. Any document bearing the common seal of the company is legally binding on the company. As per earlier companies, the common seal cannot be affixed by any director. It has to be affixed in the manner stated in the Articles of Association. Like in the presence of two directors who shall sign the document, only then the common seal can be made. But with the amendment in the section 46 of the Companies Act dealing with the share of certificates of the company, the use of common seal has been made optional. Now it is not compulsory. Now all the documents which required the affixing of the common seal, they may now instead be signed by two directors or one director and a company secretary. So it is now not compulsory that all the documents will be legally valid only if the common seal is there, but it can be either signed by two directors or one director or the company secretary, right? So the correct answer is that it made the use of common seal optional. Earlier it was not optional. This is the amendment made in section 46. Next, indicate which of the following statements are true regarding the company under the Companies Act. Which of the following statements are true? The directors are the actual owners of a company. A company has to be compulsorily registered under the Companies Act 2013. A company cannot enter into contracts in its own name. A company is a legal person with perpetual succession. Which of the following are correct? Whether A, B, and C, B and D, A and C, or B, C, and D. So, company, if we define company as given in the Companies Act of 1956, it is given in section 3 of the act. So a company formed and registered under this act or any existing company, this is the definition given, right? All the existing companies means the companies that were formed and registered before the act came into force, they have to get registered, right? So there are certain features of the company, like regarding the registration, a company has to be compulsorily registered under the Companies Act 2013, right? And the company is called an artificial legal person, which is created by law, and they can be dissolved by the law alone. Basically, this person is invisible, it is intangible, and it exists only in the eyes of the law. Thus, we use the term artificial person, artificial legal person. So the correct answer will be option 2, that is B and D only. Company has to be compulsorily registered under the Companies Act 2013, and the company is a legal person with perpetual succession. It is not a real but an artificial legal person. So the correct answer is B and D. Okay, so a company can enter into contracts in its own name, it can acquire and dispose property and can be fined under the provisions. It is a distinct entity from the members that are forming it, and because it is a distinct legal person, it has its own signature. That is the common seal with the name of the company that is engraved on it. So it is different from a partnership firm as well. Alright, so these are the following correct statements about the company. What is the meaning of perpetual succession? This will mean that the company will never die until it is wound up as per the law. Only the law will wind up or dissolve the company. Until and unless that happens, the company will have perpetual succession, right? So the insolvency or death of the members, they do not affect the continued existence of the company. That is the meaning of perpetual succession. Next, what is the time frame for converting an OPC to a private or public company after meeting the criteria for conversion? So there are different types of companies. We have a statutory company, company limited by the shares by guarantee with unlimited liability. A private company is there, OPC is a one-person company. Then we have the foreign company, government company. So there are companies on the basis of public interest, companies on the basis of mode of incorporation, then by the people on the basis of liability, holding and subsidiary companies. Here it is asking what is the time frame for converting an one person company to a private or public company. It is a direct fact based question that you should know, and the correct answer is option C, that is 6 months. So here everything about the one person company is given. It means a company which has only one person as a member, as the name suggests. So one person company shall indicate the name of the other person with his prior written consent in the prescribed form, who shall in the event of the subscriber's death become the member of the company. So when the person is forming the company, they should name another person that if this first person dies, this another person will take over, right? Such other persons may withdraw the consent as may be prescribed, and the member of the one person company can also change the name of the person as per the prescribed conditions. If the OPC they want to convert himself into a private company or a public company, they can also do so. How? They can do so it within 6 months of the date as mentioned. The Companies Act provides that when the paid up share capital of a OPC exceeds 50 lakh or its average annual turnover exceeds 2 crore, then what will happen? The OPC will be required to convert itself into a private company. And this can be done, or this should be done within 6 months of the date that is mentioned. So the correct answer is 6 months. Okay, now the question says what is the first step of the formation of a company according to the Companies Act 2013? Electing the board of directors, preparing the memorandum of association, registering the company with the government, or issuing shares to the public. What is the first step when a company is formed? So what is the memorandum of association? Basically, the name of the company should be there, the state in which the registered office of the company is situated, then the reason for which the company is being incorporated, and all the matters information considered necessary has to be provided. The liability of the members of the company, whether limited or unlimited, all of these things should be there. So the name clause, objective clause, registered office clause, liability, capital, all of these things are contained in the memorandum, and this is the first step towards creation of a company under the Companies Act. So preparation of the Memorandum of Association, which is described in detail in section 4 of the Companies Act. This is the first step. So all the necessary information regarding the name of the company, then the clause including the objectives, the state where the company is being registered, everything has to be provided. Only then can we further move with the next steps. All right. Also, there's the Articles of Association, which is different from the Memorandum of Association. You should know the difference. In the Memorandum of Association, what happens? The change of registered office is in another state, for example, has to be provided. So these are the internal regulations of the company. How the company will be managed. How the company will be managed is contained in the Articles of Association, and all the basic details of the company are in the Memorandum of Association. So the name clause, then the registration clause, the objective clause, the liability clause. The purpose of the memorandum is to enable the creditors and those who are going to deal with the company to know about the permitted scope of the activities. Thus, it is the first step towards formation of a company. Next, which statements accurately describe the implication of the doctrine of ultra vires? The doctrine of ultra vires. There are three doctrines. We have the doctrine of ultra vires, the doctrine of notice, and the doctrine of indoor management. These are very important. They deal with the rights and duties of the company with respect to the members and also with the outsiders. So, the doctrine of ultra vire, what does it state? The acts outside the scope of the objects of the clause of the Memorandum of Association are ultra vires. The ultra vires act as the within the powers of the company. The company cannot be sued for engaging in ultra vires acts. The ultra vires acts are always to be validated by a simple resolution. So according to the doctrine of ultra vires, which of the following are correct? So this doctrine states that the objects of a company that are specified in the Memorandum of Association, they can be departed from only to the extent that is permitted in the Act, not more than that. So when a company exercises its power to promote any of its objectives that are given in the Memorandum of Association, then we are talking about the intra-vires that are already given in the Memorandum of Association. However, if any other act of the company which is outside the scope or beyond the powers of the company, that are known as the ultra-vires. So I hope you can select the correct answer now. The correct answer is option 3, that is A and C. Acts that are outside the scope of the objects of the cause of the Memorandum of Association, and the company cannot be sued for engaging in the Ultra Vires Act. Within the powers are known as the intra vires. Right? So A and C. When a company exercises the powers given in the memorandum, it is known as the intra vires. When the company uses the powers, beyond what is mentioned in the Memorandum of Association, it is known as ultra vires. The company cannot sue on the ultra vires transactions. Further, it cannot be sued. Right? So this is correct about the ultra vires. I hope it is clear the difference between intra vires, ultra vires, and the basic characteristics. right? Okay. What does the principle of constructive notice seek to protect? Now, this is the second type of doctrine, that is the constructive notice. What does it seek to protect? Or what is meant by the constructive notice? The outsiders against the company, the internal management of the company against outsiders, and the shareholders of the company. So, the constructive notice basically, what does it mean? So, when we were discussing about the memorandum of association and the articles of association of the company, they are registered with the registrar of the companies. So, as the office, it is a public office. So, these documents that are given in the articles of association or memorandum of association, they become public documents. So, the act is expressly guaranteeing the right of inspection of the documents, right? However, when we are talking about these public orders, they have to be in accordance with the provisions. And it is presumed that this constructive notice is going to protect them. It will be presumed to have knowledge of the contents of the documents, all the persons who are in the company. So it will protect those persons out against the outsiders. So the company will be protected against the outsiders because now all the things that are mentioned in the articles of association or memorandum of association, they are becoming public documents that can be called for inspection. So the principle of constructive notice, they seek to protect the company against the outsiders, whereas the doctrine of indoor management seeks to protect the outsiders against the company, right? So there's a difference between the two. So it is assumed that all the persons that are dealing with the company, or they are having knowledge of the company, of the articles of association and the memorandum of association, they will be protected against the outsiders. Moreover, if I ask you whether it has a positive nature or it has a negative nature, what would you say, or what would be right to say about the nature of the doctrine of constructive notice? We can say that it is of a negative nature because it stops a person from arguing that he had no notice of the contents of the public document. So it is of a negative nature because it is assumed that all the persons will have the knowledge of all the documents that are given in the memorandum of association. So it is a negative factor. Next, if a member of a company limited by shares has paid only a part of the amount of the shares, then what is their liability? So regarding the liability of a company, if they are limited by the shares, so what will be their liability if they have only paid a part of the amount? The liability is limited to the unpaid amount of the shares. The liability is unlimited. The liability includes all the company debts, or the liability is limited to a specified sum in the memorandum of association. Yes, so the correct answer will be option A, that the liability is limited to the unpaid amount of shares only. So there are different types of companies. We have the unlimited liability company, the company that is limited by guarantee, and the company is limited by shares. So if we are talking about the unlimited liability company, the member is liable in full for all the debts of the company contracted during the period of the membership. If we are talking about the company limited by guarantee, then the member is liable to contribute a sum of the money agreed and specified in the liability clause. However, when a company is limited by the shares, then the member is liable to pay the full nominal value of shares, and then the liability will end here. If they are making a full payment, of all the shares, all the debts that are included, then the liability will end. If, however, the member has paid only a part of the amount, then his liability is limited to the unpaid amount of the shares in respect to which he is a member. If he makes the unpaid amount, also they make the payment, then they will be relieved of the liability. The liability of the member will end there. All right, so this is, we can say, a case study type of question, right? A member of the company is limited by a share, they have paid only a part of the amount, then what will be their liability? So only the unpaid amount that is left will be the liability. When can a prospectus be issued according to the Companies Act 2013? So now we are talking about the prospectus. What is a prospectus? Prospectus can be a document which is described or issued, and it includes the red herring prospectus as well. The red herring prospectus is also included, or any notice or a circular or advertisement that offers from the public for subscription. So that is a prospectus. So a public company can raise funds for its business from the public by issuing a document, then it is known as the prospectus. So when they're trying to raise funds, they are making a prospective, they are issuing a prospective. So that is known as a prospectus. So when can a prospectus be issued? Before the incorporation of the company, only after the incorporation of the company, during the company's first board meeting, or after the company starts its operations. So which of the following will be correct? Or what is a red herring prospectus, if I ask you to recall? So the it will include the obligations related to the public. It will not include the complete particles or all of the information related to the quantum or price of the securities will not included in the red herring prospectus. If we are talking about another shelf prospectus, so what is the meaning? So in which the securities or class of securities here will be mentioned, then we can say prospectus will be a document which is going to give the information about the funds that are to be created, when the shares will be listed, or how the company is willing to raise funds from the public, all of this information. So the correct answer here will be the prospectus can be issued only after the incorporation of the firm. Only after the firm gets itself incorporated can they issue the prospectus. So, a prospectus can be issued only after the incorporation of the firm. What will be the content of the prospectus? It stipulates the mandatory provision that are to be stated. What will be the date of the publication? It must be dated, and evidence of the date should be there in the publication. Signature of every director on the prospectus should be there. There should be an application form with the prospectus so that the public they can fill the application form that are issued to the underwriters and the existing shareholders as well as the debenture holders. So only after the incorporation of the company, the prospectus can be issued for raising funds from the public for its business. All right. So all the material disclosures that are required by the Companies Act will be given in the prospectus. Next, what is the minimum number of directors required for a public company according to section 149? So according to section 149 of the Act, how many directors are required to be there in the company? Minimum. In the case of a public company, right? Yes. So whether it requires one director, two directors, three directors, or four directors. Also, what are the qualifications of the director? What is the expertise that is required, what is the position of the person to be a director. All of these things are the facts from which questions can come. So the correct answer is that the minimum of directors should be 3 for a public company. So every company must have a minimum number of 3 directors in the case of public company, and 2 in the case of a private company, and 1 in the case of a one public company, a OPC. Then a maximum of 15 directors. A company may appoint more than 15 directors after passing a special resolution. Otherwise, maximum 15 has been stipulated. Now, the qualification: every company shall have at least one director who has stayed in India for a total of a period not less than 100 years and 82 days, 182 days in the previous calendar year. So if they have stayed in India, they are a resident of India in the 182 days of the previous calendar year. Every listed company shall have at least one third of the total number of directors as independent directors, and the central government may prescribe the minimum number of independent directors as the case may be. So here the question is asking us about the public company. So the minimum is 3 directors, maximum is 15, which can be increased if we get the proper permission for that. So the correct answer to this question is option C, 3 directors. Next, what requires shareholder approval if the company wants to invest the compensation received in respect of the compulsory acquisition? So a company can perform the compulsory acquisition, but before they invest the compensation, what approval or where approval will be required of the shareholders? When they're investing in the trust securities, when they're investing in the employee benefits, investing in the marketing companies, or investing otherwise than a trust security. So in which of the following condition the company will require the approval of the shareholder if they want to invest the compensation that is received in respect of a compulsory acquisition? In case of a compulsory acquisition, the correct answer will be option D, that if they are investing otherwise than in the trust security. So the board of directors of a public company or of a private company which is a subsidiary of the public company, they can exercise the following powers only after the resolution is passed to the effect by the shareholders. So here we are talking about the public company or a private company which is a subsidiary of the public company. They have to take the approval of shareholders in which condition? In the case of dispose of any undertaking of the company, if they want to remit or give time for the repayment of any debt due by the director, if they want to invest otherwise than in the trust securities, the amount that is received in compensation in respect of the compulsory acquisition, if they want to borrow money in excess of the aggregate or paid up capital, and if they want to contribute to charitable and other funds not directly relating to the business, right? So these are the situations or the conditions where the company has to receive the approval of the shareholders. Otherwise, they cannot perform these actions. So if they want to invest in the trust, invest anywhere other than the trust of the company's trust securities, then they will have to seek approval of the shareholders. Next, what type of succession does a limited liability partnership have according to section 3 clause 2? So very direct questions are there. If you would have read this chapter, you have read about this particular act, the Limited Liability Partnership Act of 2008, then you can answer this. What type of succession does LLP have? Does it have a perpetual succession, a temporary succession, a limited succession, or no succession? So we have various definitions given under the limited liability partnership form. Like we have the appellate tribunal. The appellate tribunal will be the National Company Law. Yes, the National Company Law Appellate Tribunal.
Then body corporate will be stated. It includes the limited liability partnership, a company that is incorporated outside India. The court will refer to the court having jurisdiction as per the act. The designated partner will be any partner which is designated as such given in the section 7. Foreign limited liability firm is also there. Then we have the partnership agreement. So various things are given. Accordingly, what else is given? The succession. So the succession in a limited liability firm will be of the form of a perpetual succession. Of a perpetual succession. It means continuous. Until otherwise stated, the company will continue to be in existence. It is not temporary, limited, or no succession, but perpetual succession is there. So the correct answer is A, that it will continue until it is otherwise stated. Okay, so the correct answer is A. Next, according to section 56, which type of company may convert into a limited liability company? So there's an option given under section 56 of the act that a company may convert into a limited liability partnership. Which of the following companies have this power? Public company, a private company, a listed company, or a government company? Which company can convert itself into a limited liability partnership firm? So these rules are regarding the different conversions such as the partnership to a LLP or a private company to LLP. These are given under the section 55 to 58 of the act. The section 55 to 58. And here we have been asked about specifically section 56, and section 56 talks about the private company. Right? Section 55 talks about the limited liability partnership a firm may convert into a LLP according to the chapter and second schedule of section 55. Section 56 talks about the private company may convert into a limited liability partnership. Also an unlisted public company as per the section 57, unlisted public company can be converted, and accordingly their conversion registration and rules are given under section 58. So yes, this is the conversion from private company to a limited liability company, conversion from the unlisted public company to a LLP. As per section 57, unlisted public company may convert to a limited liability partnership. So these options are there. Okay. Which statements are true about the parties involved in a mortgage according to section 58A? Now we have moved on to the mortgage, and it is asking the transferor is called a mortgager, the transferee is called a lessee, the transferee is called a mortgagee, or the transferee is called the tenant. Again, use the same concept, word ending with OR and word ending with double E. So the person who is making the transfer, the transferor, will it be called the tenant or the mortgager? It will be called the mortgager, and the person to whom the transfer is being made will be called the mortgagee. Same relationship applies everywhere. So a mortgage is the transfer of an interest in specific immovable property to secure the payment of money given by the way of loan or to secure the performance of an engagement. The transferor is known as the mortgager and the transferee is known as the mortgagee. And the principal money and interest secured will be known as the mortgage money. So if you are asked about what will be included in the mortgage money, you should know it will include both the principal money as well as the interest that is secured. And if we are talking about if any instrument is being transferred, then it is known as the mortgage deed. So here all the definitions are given. The mortgage, the mortgager, mortgagee, the mortgage deed. This is under the Transfer of Property Act of 1882 that the mortgage related information is given. So the transfer of property will mean that a living person is conveying the property in present or in future, right, to other people. And mortgage, we talk about the of the immovable property, transfer of the interest or the movable property when we take the transfer of the instrument themselves, the mortgage deed. We have various types of mortgage, like we have the simple mortgage, the conditional mortgage. We have studied about this in the previous unit also. The usufructuary mortgage, English mortgage by the title deeds, right? So what happens to the possession of the mortgage property in a simple mortgage? What are the conditions under a simple mortgage? The mortgager retains the possession of the property. The mortgager delivers the possession to the mortgagee. The property is held by a third party, or the mortgagee takes possession immediately. So if we revise what is a simple mortgage, so what is happening, without delivering the possession of the mortgage property, the mortgager binds himself to pay the mortgage money. What is happening, they are binding themselves to pay the mortgage money, they're not delivering the possession of the property. And if in the event of the failing to pay, the mortgagee shall have the right to cause the mortgage property to be sold, and the proceeds of the sales are to be applied. So what are the basic essentials? The mortgager does not deliver the possession of the mortgage property. The mortgager binds himself personally to pay the mortgage money. And the mortgager agrees that if they are failing to pay according to the contract, only then the mortgagee shall have the right to get the mortgage property sold and recover their dues. So these are the essential qualities or characteristics of a simple mortgage. And the correct answer accordingly will be option A, that the mortgager retains the possession of the property, right? So they are binding themselves personally to pay the mortgage money, and it will be sold only if the mortgager fails to pay accordingly to the contract. So they are retaining the possession of the property with themselves. Next, what are the requirements for a mortgage other than a mortgage by deposit of title deeds? So this is another type of mortgage, that is mortgage by deposit of title deeds. So which of the following statements are correct? It must be effected by a mortgage deed duly signed by the mortgager. It must be attested by at least two witnesses. It can be created verbally without any documentation, or it requires approval from the central government. Which of the following statements are correct for this type of mortgage? Yes, try to answer this question. The correct answer will be option A, that is A and B only. It must be effected by a mortgage deed that is duly signed by the mortgager, and it must be attested by at least two witnesses. It cannot be created verbally, and it does not require the approval from central government. So A and B are correct. So, where a person in any of the following towns, namely Calcutta, Madras, and Bombay, or any other town that is stipulated by the state government, delivers to the creditor or his agent the documents of title to the immovable property, then this transaction is known as the mortgage by deposit of title deeds. What they are doing, they are transferring the title to the ownership or title to the deed of the immovable property. So what are the characteristics? The mortgager delivers to a creditor or his agent the title to the immovable property with intent to create a security thereon. The delivery of the title is done in the towns that are Calcutta, Madras, and Bombay, and the property is given as a mortgage, may or may not be situated in the specified towns. That is why we are transferring the title deeds of the property. Right? So this is the correct answer, A and B. Then, is notice to a debtor mandatory before the transfer of an actionable claim? Does it require to give a notice to the debtor before the transfer of an actionable claim is done? The correct answer will be option B, that it is not mandatory. It is not mandatory. Actionable claim, what is the meaning of actionable claim? It means a claim to any debt other than that is secured by a mortgage, hypothecation or pledge, or to any beneficial interest in the movable property not in possession, which the civil court recognizes as given receipt. So when we talk about the transfer of actionable claim, it is with or without consideration, which can be done only by the execution of the instrument in writing that is signed by the transferor. And there is no mandatory requirement of giving notice to the debtor before the transfer of the actionable claim is made. That transferee can they can sue the debtor in his own name without obtaining the transferor's consent and without making him pay a party to the suit. So it is not mandatory that a notice to be made to the debtor before the transfer of the actionable claim. Okay. So let's say if we are saying A owes money to B and B transfers this debt to C, but A is not aware of that. The contract is between A and B. A is owning this money to B and B is transferring this debt to C. But A does not know about this transfer. And then B demands the debt from A and A pays B. So this payment will still be considered valid and C cannot sue A for the debt because A was not aware. A has made the payment to B and thus it will be valid. Alright. So C cannot sue A for the debt. So the correct answer is option B. Then what happened to the Freedom of Information Act 2002 when the new act came into force on October 12th, 2005? So now we are talking about the Right to Information Act which came in 2005. Before that, what was working? The Freedom of Information Act 2002. So what happened to this Freedom of Information Act? It was actually repealed when the new act came into force. So there were amendments that were made to the act with effect from 2019, which extends to the whole of India, right? Then, while the provisions of the act relating to the obligations of public authority, the designation of public information officers, assistant public information officers, all of these, the non-applicability, here we can seek information related to any of the action. This is the Right to Information Act to provide for setting up out the right to information to the citizens so that they can have access to the information under the control of the public authorities, to promote transparency and accountability. Also it aims at containing the corruption and holding of the government and their instrumentalities accountable. So access to information is provided to the citizens, right? On coming into force of this act, the Freedom of Information Act 2002 was repealed. Now all the public sector banks, institutions owned and controlled by the government are public authorities. They're also required to comply with the provisions of the act. So the correct answer is option B, that it was repealed. Next, which responsibilities are associated with the Central Information Commission according to section 2B? So, the Central Information Commission and the State Information Commissions are accordingly formed. What are the responsibilities? They are constituted by the central government. Their responsibility is to oversee the local municipal issues, managing the private sector information, implementing information related legislation at the national level. So which of the following are the responsibilities of the Central Public Information? So Central Information Commission is constituted by the central government, yes. Then we also have the state commission that is formed. We have the Central Public Information Officer. includes a central assistant public information officer as well. So the responsibilities of the CIC is A and D, that they are constituted by the central government and they manage the private sector information. Okay, so sorry, A and D. A and D, implementing the information related legislation at the national level. So, herein the central government is the appropriate authority if the concerned authority is established, constituted, owned, or controlled by the government. It is the state government that is going to establish it at the local municipal level. So, the Central Information Commission is going to function at the central or the national level under the central government. Then, within what time frame must the PIO provide a requested information or reject the request? Within 15 days of receipt of the request, within 30 days of receipt of the request, within 45 days of receipt of the request, or 60 days on the receipt of the request. So the public information officer, they have the right to seek any information related to the inspection of work, documents and so on, and they have to do so within certain time frame. This time frame is within 30 days on the receipt of the request. So the PIO shall deal with the request from the person seeking information, and where the request cannot be made in writing, to render the reasonable assistance. So if the information requested for is held, or is it is subject matter is closely connected with the function of another public authority, then the PIOs shall transfer within 5 days the request to other public authority. They may seek assistance for the proper discharge of their duty. On the receipt of the request, they have to do this as quickly as possible, that they have to request for the information that is asked for in the request that is made, and this has to be done within 30 days of the receipt of the request. Either they will provide the information on the payment of such fee as prescribed, or they will reject the request for any of the reasons specified. All right. And when we are talking about the concerns of life or liberty of a person, then this time period will be 48 hours of the receipt of the request. Otherwise, 30 days limit has been kept for the seeking of information. Next question. Which complaints can be handled by the Central Information Commission under the Information Technology Act? Complaints about reasonable fees for the information requests, complaints about workplace harassment, complaints about not receiving a response to an information request, complaints about the property taxes. So which of the following complaints can be handled by the Central Information Commission under the Information Technology Act? The correct answer is option A, that is A and C only. If there is any complaint about the unreasonable fee or not receiving a response to the information request. So, they are empowered to receive and inquire into a complaint from any person who has been unable to submit a request to the Central Public Information Officer, or who has been refused access to any information, who has not been given a due response for the request of information, or they were made to pay a fee that they consider unreasonable. They feel that they have been given incomplete, misleading, or false information, or any other matter under the act. So, if a person who has filed a complaint to the public officer, to the Central Public Information Officer, if they feel that unreasonable fees has been asked, or information given is misleading, or they're not receiving a response, then they can immediately make the complaint to the Central Information Commission for taking into consideration. Next, what is the maximum penalty that the Central Information Commission can impose for the non-compliance? If the Central Information Commission gives an order to give out certain information or perform a duty, and if there is non-compliance, that the authority does not comply to it, then what will happen? The Central Information Commission can impose a penalty. What is the maximum penalty that can be given? whether it is 10,000 rupees, 15,000 rupees, 20,000 rupees, or 25,000 rupees. The correct answer is option D. It is 25,000 rupees. So the CIC has the power to impose a penalty of 250 rupees for each day till the information is furnished, subject to a maximum of 25,000 rupees. So each day, when the delay is happening, for each delay for each day, 250 rupees penalty will be applied till 25,000 rupees maximum is reached. They shall give the opportunity to the parties of that are being heard before imposing any penalty. They've also the power to recommend taking any disciplinary action against the central public information officer if they are satisfied that without any reasonable cause they are failing to provide the information, they have not provided the information in the time specified, they have denied the request of information, or they are giving incorrect, incomplete, or misleading information, they have destroyed information, or they are obstructing in the furnishing of the information, then what they can do, they can impose penalty as well as take disciplinary action against the central public information officer. Next, when did the Indian Parliament pass the Information Technology Bill? Very simple question. When was the Information Technology Bill passed? It was passed in August 2000. So the General Assembly of the United Nations, they by resolution dated to adopt the model law on electronic commerce adopted by the UNC, the United Nations Commission on International Trade Law. Accordingly, it was said that the nations and the governments, they have to come into contact, they have to make operational and information technology bill. Therefore, the government, they agreed, and in May 2000 both the houses of the Indian Parliament, they passed the information technology bill. It received assent in the parliament in August 2000, and it was later on came to be known as the information technology bill. The cyber laws are contained in the IT Act of 2000. Alright, so it came into force when? In August 2000. Then, who has the jurisdiction to try offences specified under Section 3, Clause 1 of the Prevention of Corruption Act? The Prevention of Corruption Act, who has the right to try the offences, who has the jurisdiction? Special judges only, local magistrates, high court judges, or Supreme Court judges. So the Prevention of Corruption Act that came in 1988, it stipulates that these cases will be under the jurisdiction of only the special judges. So Section 4 stipulates that the offences under the Act shall be tried by special judges only, and it also lays down the rules that are to be followed under the cases. So they shall be tried by special judges. Every offence that are specified in the Act will be tried by the special judge for the area within which it was committed, or if a special judge is separately appointed for the case. So this came in 1988, basically related to the cases where the public servants or other authorities, they're involved in corruption, to dealing with those cases. So the related to, let's say, any person who is the chancellor of a governing body, a professor or reader when we are talking about education institute, secretary or office bearer of a cooperative society. Then they are, if any person has been appointed to perform a public duty, so persons that are failing to perform their duty or they are involved in corruption, they will be treated under the particular act, and their cases will be held by the special judges. So those cases, or notwithstanding anything contained in the Code of Criminal Procedure, all of these things are there. Then, in the metropolitan areas of Bombay, Calcutta, Madras, and Ahmedabad, who is authorized to investigate the offences under the Prevention of Corruption Act? So, this is given specifically for these particular metropolitan areas. Who is authorized to investigate the offences under the Prevention of Corruption Act? Whether it is a sub inspector of police, a deputy commissioner of the police, an assistant commissioner or a superintendent of police? The correct answer here will be option C, that is an assistant commissioner of the police. This is given under section 17 of the act, that the persons so authorized are no police officer below the rank of, in case of the Delhi Special Police Establishment, an inspector of the police. In the metropolitan areas of Bombay, Calcutta, Madras and Ahmedabad, they should be of the position of assistant commissioner of police. Elsewhere, anywhere except these areas mentioned, a deputy superintendent of police or a police officer of the equivalent rank. Right? So the correct answer is assistant commissioner of the police. Next, what is stated about the court's power to stay proceedings on any other grounds under the Prevention on Corruption Act? So, if under the Prevention of Corruption Act certain decisions are taken, then what will be the powers of the court to stay proceedings? The court can stay proceedings on any ground. The court cannot stay proceedings on any ground. The court must consult the higher authorities before staying proceedings, or the court can stay proceedings with the consent of both the parties. Where does the court have the right to stay proceedings under the PC Act? The correct answer will be option C, that is, they cannot do so before consulting the higher authorities. Yes, it is C. So, no finding, sentence, or order passed by the special judge shall be reversed or altered by a court in appeal, confirmation, or revision, or any other error that is sanctioned required under the subsection. The court cannot change, alter, put a stay on the decision taken by the special judge until and unless in the opinion of the court, the failure of justice has in fact been occasioned, or no court shall stay the proceedings on the ground of any error, omission, irregularity, unless it is satisfied that this omission has definitely occurred. And regarding the stay on the proceedings, they cannot do so in any other ground before they are consulting with the higher authorities. So, no court shall stay the proceedings under the Act on any ground, and no court shall exercise the powers of revision or appeal to other proceedings. So we can say sufficient powers are given to the special judges under the Prevention of Corruption Act, and accordingly other courts, they cannot stay proceedings before consulting the higher authorities. And that is all. We have extended our session a bit, but we have completed the module D, all the acts. These were very important. So make sure that you download the PDF and you revise all of the topics, all of the information, explanation that are given in the PDF. Now we have completed the 4 modules, but today we'll have another marathon session at 9 p.m. We will cover the case studies. Although I've stated earlier that case studies are not coming from anywhere else, you need to have the conceptual idea, the information, and you'll easily solve the case studies. Still, we'll practice a few case studies so that in the examination we have an idea how to approach them. So this case study session will be today at 9 p.m. on this channel. So I will see you today 9 p.m. Till then, have a great day. Keep revising. Thank you for attending the session. If you have any query, any doubt, any feedback, do let me know in the comment section.